Hello everyone and very welcome to your favorite channel Study Era. So friends, today we are going to study the chapter Federal Judiciary. Okay, so as we all know that courts are the essential in all organized societies. Okay, their organizations and roles vary with the form of government, political theories, social and economic systems. Okay, so government must have a strong judiciary which shall remove not only the defects of the confederation but also provide harmony among the conflicting decisions of the highest state courts. So, first of all, we are going to study the Supreme Court. Okay, so its organization. The federal judiciary is the creation of constitution as it has been specifically mentioned in Article 3rd of the American Constitution. The Supreme Court stands at the apex of the American judicial pyramid and since the early 1930s have been housed in an imposing marble structure facing across the park towards the east front of the national capital. Judges always varied from 5 to 10 in Supreme Court and today time the Supreme Court consists of one chief justice and 8 associated judges. Now appointments. So all the judges are appointed by the president and with the advice and consent of the Senate because Senate is the most important part of that constitution and the American confederation. So the rule of senatorial courtesy does not limit the choice of the president here. Now tenure. So the judges hold office during good behavior and are removable by impeachment only. He may retire at 65 with the 15 years of service or at age of 70 with the 10 years of service at his credit and receive full pay for life. If we talk about sessions, so the Supreme Court holds one regular session every year beginning on the first Monday in October and ending early in the following June. Special sessions may be called by the Chief Justice when the court is adjourned, but the occasion must be a unusual importance or urgency. The court conducts hearing on Tuesday, Wednesday, Thursday, Friday. On Saturday, the judges confer among themselves and register their opinion. And on Monday, the judgment are delivered in public. The decision of the Supreme Court are published in the United States reports as so that all the people living in America can go through it. Its jurisdiction. So, Section 2, Article 3rd of the Constitution and the jurisdiction has written there and the Supreme Court of America has both the original and appellate jurisdiction. So original is when cases involve ambassadors, other public ministers and consuls. Okay, so a very few cases come to purview of the Supreme Court in the original jurisdiction, and in appellate jurisdiction it hears appeals in cases already decided either in the state court or in lower federal courts. In some cases it can review the decision of the court's claim and the courts of custom and the patent appeals as well. As a court of review, appeal from the highest court goes directly to the Supreme Court. In the case which have been heard and decided by the Supreme Court, no appeal can lie with any other authority. The judgment of the Supreme Court are considered as final. No advisory jurisdiction. The Supreme Court of America, unlike the Supreme Court of India, does not perform the advisory function. In USA, the apex court has refused to advise the executive on hypothetical questions. Okay, nor does the court pass judgment upon the political questions. It acts only when a law has been violated and the matter is raised in a specific suit. And Supreme Court at work. So for a session, quorum of 6 judges is required. Judges arrive at decision by a majority vote only. All the decisions, opinions of the Supreme Court are published in the United States Report for Record and Guidance of the Legal Profession and General Public. So role of the Supreme Court as a protector of federation. It's an on account of the liberal interpretation by Supreme Court that the federal structure devised in the 18th century to satisfy the requirement of 13 states with a small population living in a pastoral cum agriculture age is fully suitable to the needs of most industrialized country consisting of 50 states today. Without a liberal interpretation by the Supreme Court, the US federalism might have collapsed. Or, second, a savior of the Constitution. It can declare null and void a law passed by the legislature and any order issued by the executive organ in US if it is repugnant to the Constitution. Its power of judicial review has at times protected by the Constitution from being violated and has checkmated the monarchical ambition of the president and the democratic recklessness of the Congress. Guardian of the right. Okay, so as a guardian of the rights, the Supreme Court has been empowered to issue writs like habeas corpus, mandamus, certiorari, and for the protection of these rights of the people only. It has declared laws unconstitutional not only on the basis that they are beyond the jurisdiction of the particular organ, but also on the ground that they were unremarkable or unjust. So restricted the protection given to property. The Supreme Court has done much towards the growth of constitution. The necessary adoption could not have been secured through constitutional amendments as the constitution amending procedure is extraordinarily rigid. In case of America, the Supreme Court has played a significant role in the adapting of 18th century's constitution to the space age needs to nuclear America. Highest Court of Appeal, Supreme Court. Its judgment is final. Supreme Court is an institution of a great importance in the American federal system. You can note this. Now we come to judicial review. So first we'll go through with the meaning of judicial review. What is the meaning of judicial review? So the power of the judiciary to determine whether a law passed by Congress or any law enacted by state legislature or any provision in the state constitution or any other public regulation having the force of law is in consonance with the constitution or not. If it is not, the court refuses to give effect to the statute in the question. This power to interrupt the constitution and determine the constitutionality of the statute is called power of judicial review. Judicial review made the Supreme Court the most powerful judicial tribunal in the world. The most powerful tribunal. Origin of judicial review is from one case of Marbury versus Madison, which was decided in 1803. The fact of this case was that the Congress had provided in the Judiciary Act of 1789 that request for the writ of mandamus might originate in the Supreme Court. On the night of 3rd March 1801, this is the case I'm telling you, Marbury had been appointed Justice of Peace for the District of Columbia by President Adams, whose term expired before the commission was delivered. The incoming President Jefferson and his Secretary of State Madison refused to deliver the commission to Marbury, who immediately petitioned to the Supreme Court for the issue to writ of mandamus under the Judiciary Act 1789. Chief Justice Marshall, who wrote the judgment, declared that Supreme Court had no authority to issue the writ because Judiciary Act of 1789 had enlarged the original jurisdiction of the Supreme Court as prescribed by the Constitution and therefore it was null and void. So this was the case between Marbury and Madison from where the judicial review has its origin. Now let's go through with the New Deal period. What is New Deal period? So the period of 1930s was a period of economic depression in America. We all know that very much economic crisis were going on. So Mr. Roosevelt, who took over as president in March 1933, promised a new deal to steer the country out of economic chaos. Okay. Supreme Court declared 5 of New Deal statutes unconstitutional, which were given by the President Roosevelt. Okay. So 3 years of its battle between Supreme Court and Mr. Roosevelt, who was a president that time. So a court believed that the New Deal measure represented bad economic and bad government. Advocates of New Deal were convinced that economic and political thinking of the judges were obsolete and should no longer be permitted to determine whether a statute was constitutional or unconstitutional. Roosevelt was re elected in November 1936 and decided to put through his New Deal program by reorganizing federal judiciary. The immediate target was his proposal were the aged judges in the Supreme Court and lower courts. The most significant proposal was to give the president the power to appoint an additional judges for every member of the court who had served for 10 years and who remained on the bench after reaching the age of 70, provided the number of judges should never exceed 15. This proposal, it was presumed, would tend to embarrass older judges into retiring or resigning. The president might have appointed 6 additional judges, raising the membership of court to a maximum of 15. The proposal of rejuvenate the Supreme Court was defeated in the Congress in its entirety. But the president won in another way. Vacancies soon occurred by resignation, retirement, or death, and younger men were appointed against these vacancies. The supremacy still belongs to the Constitution. Here you can conclude this. Here are some criticisms of the power of judicial review. So first is it has become non-elective super legislature, means the man criticism against the power of judicial review is that it has made the Supreme Court non-elective super legislature. Just means some philosophers are there who says that, like Lasky calls it as a third chamber. The court, while deciding the cases, act as a quasi political body and determines not only the constitutionality but the propriety and justness of the law. So second is one man tyranny. The decision of the court have taken place by majority vote. It has often resulted in one man tyranny. The critics have pointed out that the laws have been declared unconstitutional by 5 to 4 decisions. That is, decisions in which 5 of the judges holds it to be invalid. In other words, we can say this like it means that the opinion of the single judge may set aside the action of the duly elected Congress and the President. The criticism term it as one man tyranny. Now, third is it has clogged social progress. The excessive dependence on legal formulas shown by the judges has seriously retarded social progress. Conservative check means the judge make an effort to uphold the 18th century constitution and try to maintain its supremacy. The judges uphold conservatism and stand for anarchistic ideas of 18th century in the 21st century. Hence, the critics consider judicial review as a source of fortress of conservatism. So, in a period of about 200 years or so, the Supreme Court has invalidated only about 100 laws and about of 70,000 passed by the Congress. In most of the nullified laws, only a part of law concerned was declared unconstitutional. Power of judicial review constitute the ultimate safeguard of individual liberty. In Great Britain, the need for judicial review has not been felt because in that country the executive is responsible to the legislature, and in case of America, it is not so. So it is true, no doubt. Monroe writes, it is true, no doubts that 5 to 4 decisions could not be made without the vote of 50 judges, but neither could it be made without the votes of other 4. Supreme Court has from time to time upheld progressive measures also. The Supreme Court has always continued to act as a protector of those rights which are guaranteed to the individual minorities by the Constitution. Federal Court of Appeal 13 federal courts of appeal, one in each of 12 judicial circuits. Judges always vary from 3 to 6 years. The Chief Justice presides over a conference of the senior federal court judges from various circuits, which is held in Washington at least once a year. District courts 94 US district courts are there. There are several judges for a single district. They do not sit together, never. Occasional removal of misbehavior either by impeachment or by demand backed by the threat of impeachment, but such action have been rare. The appointments to the district judges are subject to the senatorial approval. And herein, the rule of senatorial courtesy plays its full part. Special federal courts, Supreme Courts, the federal courts of appeal, and the district courts have been categorized as constitutional courts. Article 3 to excise judicial review of these courts have been established under Article 3 to excise the judicial review of the United States. Custom courts, it has 9 judges and the court's office is located in the city of New York. The function of the court is to decide controversies as to valuation and duties arising under the tariff. Courts of custom and patent appeals. It consists of 5 members, usually in Washington. Here's appeal from custom courts. Means the custom courts give the appeals to it and it deals with it. Territorial courts, set up by the Congress in American territories. These courts have jurisdiction over all matters local as well as federal. Tax court, 16 members are there. Here's disputes arising from decisions of federal tax collection agencies. Courts of military appeals, 3 civilian judges are there. It functions in Washington. Here's appeal against the decision of court martials. So thank you very much. Please like, subscribe and share the channel.